everyone. My name is Sian Keel. I'm one of the partners in the employment team at Travers Smith. And with me today is Anna West, who is a knowledge counsel on our team. Welcome to our webinar on remote investigations. We've been doing a lot of work in this area in recent months, and we'll be sharing with you today some of the practical issues we've been talking to our clients about. Today we're going to be talking about the 4 different stages of an investigation: the initial complaint, the pre-investigation steps, the investigation, and the outcome. Those are not exactly steps that you can always take apart in the way we have. We've just tried to put them together in a way that seems logical and helpful. But we're going to pick up today on the practical issues we want you to think about, and also particular areas where the remote nature of an investigation might have an impact on the way that you approach it. And we'll round up with some key points for you to take away. Now, something that's very important but easily overlooked is the importance of taking time to plan the investigation before you kick it off. It sounds really obvious, but there can be a big tendency and some pressure to feel that you need to get going straight away. But there are a lot of things you need to think about and have in place in advance if you want to make sure your investigation is as thorough as it can be. And we're going to be looking at those today. So first, Anna, do you want to start us off at the very beginning when the complaint comes in?
Yes, thank you, Sian. So this is the first of our 4 stages when the complaint is made. And we wanted to spend a few minutes on this because the way the complaint is made is going to affect how you investigate it. More often than not, it will be made by the employee themselves, although it could be made by someone else, which I'll come on to. And when we're talking about complaints here, this might be a grievance or it might be a whistleblowing disclosure, and what we say on investigations is relevant to both. If the employee's raised a grievance, they might have done so in confidence, which is sometimes the case with a harassment or bullying complaint. They might say they don't want the person they complained about to know, and that will obviously affect how you carry out the investigation, and we'll come on to talk about that. The employee might have raised a complaint anonymously through your whistleblowing or your speak up channels, which might restrict the extent to which you can investigate that complaint. And again, we'll pick this up when we talk about process. And sometimes a complaint or a whistleblowing disclosure will be raised by someone who has witnessed something which they're unhappy about, such as harassment or bullying, even though it wasn't directed at them. Or they might have been told in confidence by a colleague about something that happened that they feel they have to raise, but they can't tell you who told them, so you have second-hand information. Obviously, it still needs to be investigated, but again, this will impact how you carry out the investigation, and we'll touch on this later as well. So after the complaint has come in, the next stage is to consider your pre-investigation steps, which, as Sian said, should ideally all be in place before the investigation starts. One of the first considerations is who else needs to know about this complaint? Who's going to be on your internal team? That will depend to some extent on what the complaint is about. For example, if it involves some sort of technical issue, you'll need someone familiar with that aspect. You also need to think ahead about who might hold any subsequent disciplinary hearing and potentially any appeal, as they shouldn't be involved in the investigation process. Also, in terms of who's going to be involved internally, whether that's as part of the investigation team or as a witness, are any of them currently on furlough? If they are, you can still involve them in the investigation, but you'll need to consider whether the time they spend on that is working time for the purpose of your furlough claim. There isn't really any clear guidance on this, but in broad terms, being a witness during furlough probably doesn't amount to working, whereas carrying out any investigatory role is more likely to amount to work. But the question is very fact-specific and something you would want to take advice on in relation to the employee's particular role. Also, will the investigation be carried out by someone internally, or will you appoint an external investigator? That may partly depend on what the allegations involve, because if it's something specialist, you may have to look to external experts. Some organisations ask lawyers to carry out the investigation on their behalf. It's becoming increasingly common, and it's something that we've done on many occasions. And one question we often get asked is whether the investigation documents and correspondence around that is protected by legal professional privilege if it's carried out by lawyers. Now, as you may know, if documents are privileged, they don't need to be disclosed in any employment tribunal proceedings. Now, legal privilege is quite a complex area, but we think that in most cases it is unlikely to cover the investigation documents like investigation notes and reports. But in any event, it's not necessarily helpful to try to claim legal privilege over the documents anyway. Most of the time, if an employer is appointing lawyers to carry out an investigation, it's because they want to demonstrate that the investigation has been carried out independently and thoroughly. And to that end, they wouldn't want to be trying to conceal the documents in any employment tribunal proceedings. They would want to use them to show that the investigation was done properly. So there also may be other third parties who need to be notified about the investigation. You'll need to give that some thought in advance. So for example, if you're in the financial services sector, you may need to tell the FCA about concerns that have been raised. If there's a criminal angle, the police may need to be involved, and you'll need to liaise with them to ensure that you're not doing anything which may cause difficulties with any investigation that they're doing. Depending on the nature of the complaint and the type of business you have, there may be concerns about possible media interest and negative reporting. And if so, you might consider involving external PR professionals at an early stage to help you to handle the communications. And other pre-investigation steps in the slide there involve protecting your employee and protecting evidence. So looking at protecting your employee first, this is a particularly important consideration if the employee has claimed that they've been bullied or harassed, or they've seen someone else being bullied or harassed. You'll want to make sure that the victim is protected from the kind of behaviour continuing, and also any potential retaliation by the person that's being complained about. And the way that you might protect them is a bit different now in the remote working environment than it would have been when everyone was physically in the office. So in that situation, you may have ended up suspending the alleged bully during the investigation because it may be difficult for the employee who complained to continue working for them. Now, there may be less of an immediate need to consider suspension because with everyone working remotely, there's less scope for retaliation. But you would still need to think about whether you do need to take any steps to protect the employee. So for example, are they reporting to the person they complained about and having to deal with them regularly? In some ways, bullying or harassment may be even more damaging to the employee with everyone working remotely because they may feel there's no escape or safe haven for them, even in their own home. So you might need to consider something like temporarily changing reporting lines. They don't have to deal with each other. And if the issue is serious enough, you may decide that you're going to suspend the alleged bully in any event. And if you do, in some ways, this is easier when everyone's working remotely because the person's absence is not so visible to so many people. So not everyone needs to know about it. Consideration of suspension is also relevant when it comes to protecting evidence. So depending on what the allegations involve, there may be a concern that once the individual knows they're being investigated, they try to destroy evidence or they try to interfere with potential witnesses and hamper the investigation that way. So you need to give that some thought before you start the investigation and about how you protect against that risk. And it might be that suspension is the answer if there's no other way to protect evidence or witnesses. Or it might be that if evidence is contained in a certain place on your system, you may be able to prevent access to that, and that may be enough. So once you've done all of those pre-investigation steps and you've got everything in place, that's when you can move on to conduct the investigation. And Sean, that's probably the area where remote working has the most practical impact, isn't it?
Yes, that's right, Anna. There's a lot to think about here, both in terms of interviewing witnesses and reviewing the relevant evidence. Picking up first on the physical evidence, so documents or messages, depending on what you need to look at, this may be more challenging in a remote working environment, and you may need to think about whether someone needs to go into the office to access any hard copy documents. If so, who should this be, and do any confidentiality issues arise? More commonly, you will probably need to line up somebody from IT if you're having to search emails, and you'll have to consider what you tell them and how you can keep the investigation confidential. Or if they're going to need to know something about the investigation in order to do the search, you should make sure it's someone sufficiently senior and that they know the importance of keeping the details confidential. One thing you might end up doing is taking copies of mailboxes at different dates so that you can see when and whether anything has been deleted. Now, one word of caution, one of the risks with searching IT systems is this can affect the way the mailbox appears, and the employee may know that it's being looked at. We've, on a number of investigations, worked with forensic IT specialists to ensure that the system is duplicated and then searched in such a way that it doesn't affect the integrity of the account. And that's something that's worth considering in the right sort of case. Now, separately, you might find that you need to obtain an employee's work phone or other device as part of the investigation. This is tricky anyway, but is even more complicated in a remote working environment, as they won't be in the office with the devices. If you have concerns they may delete information, you might eventually need to arrange for someone to turn up and collect the devices at the same time they're told about the investigation, which is a bit extreme, but in some situations it might be an option you need to consider, but certainly you wouldn't want to do that without carefully considering your options and taking advice. Now, moving on to witnesses, you'll obviously need to interview witnesses in most investigations. So you'd be interviewing the employee who raised the complaint normally, and anyone else who is involved, and that list of people may change over time. We mentioned earlier that sometimes an employee raises a complaint and asks that their identity is not revealed to the person they're complaining about, which often happens in bullying and harassment cases. This is tricky and does limit what you can do by way of investigation, but you have to do what you can. So you might check through the emails of the person they've complained about, or perhaps talk to other team members, for example, to find out their experiences. And you can, of course, and actually this often does happen, go back to the person who raised the complaint and explain where you've got to, and ask if they still feel the same way about staying anonymous, or whether they're prepared to let you move forward using their name in order to actually get to the bottom of the investigation. Now, when you're interviewing witnesses, you will need to make sure that they have any relevant documents and information to hand. Again, this requires more thought in the remote environment, particularly making sure that you respect confidentiality and keep information secure. Because if you were physically in the office, you'd just have the documents in a meeting room for the witness to see, but not be able to take away. And obviously this is more difficult to achieve remotely. So you need to think about how you might send relevant evidence and documents to those involved in the investigation, how you might make sure that's kept secure and confidential, given that employees will be accessing it from home, how it can be deleted or access restricted when they no longer need it. And you'll want to involve your IT team to consider these issues, including issues such as encryption and passwords, and also potentially removing documents from their device afterwards. Something else that might need a little more thought in the remote environment is how you schedule the witness interviews, as the order of interviews can be important. You may, for example, be concerned that witnesses might speak to each other to agree their story, or one may tell another about the interview so they can prepare their response. So you might think about interviewing them immediately one after another. In the office, if you do this, you can make sure they don't speak to each other between the interviews. But obviously remotely, this is more difficult, as you won't be able to see if, for example, the person you just interviewed immediately messages another witness. Depending on how many people are involved in the investigation, you could potentially have two witnesses interviewed simultaneously, although that's probably not ideal because the person investigating will probably want to have interviewed both themselves. One thing which is made easier in the remote environment is conducting interviews in an unobtrusive way. In the office, it can be tricky to keep investigations quiet if people see their colleagues going off to meeting rooms one after another. But in the remote world, they needn't know this is happening. Now, the next thing to consider is the interviews will all be online over a platform, Zoom as an example, and this poses a few practical issues. It can be harder to gauge a witness's reaction over video as well as you do in real life, as you can't see their facial reactions as clearly or their body language. This is not always a problem, but it can make it more difficult for the investigator in cases where a witness's credibility is key. Also, as the witness will be at home, you need to think about confidentiality and may want to ask the witness to confirm there isn't anyone else in earshot, especially if there are sensitive details being disclosed about another employee. But there's another consideration here, which is whether the person who's raised the complaint or the person who's being investigated might want to have a family member or housemate with them as their companion. Now, as you probably know, there's no legal right to be accompanied to an investigation meeting, as opposed to a grievance or disciplinary hearing where the employee can be accompanied by a colleague or a trade union representative. But some employers have been allowing employees to be accompanied to investigation meetings as part of their internal procedure. And if an employee asks to be accompanied, you may want to consider agreeing to this, given that people can feel very isolated in the current situation and may feel they need greater support than they usually would. It's something to weigh up, considering the employee's position and also the need for confidentiality around the information which may be revealed about other employees. Essentially, it's a balancing act. Another topic that's come up when it comes to remote interviews is recording. Obviously, this can be done easily and unobtrusively on a video interview compared to recording in the office, but it of course may still inhibit a witness from feeling able to speak freely and react naturally. So there are disadvantages. Audio recording only might be an option and may feel less intrusive and less distracting. If you do decide to record the meeting, the advantage is you'll have a clear record of what was said and there can't be any dispute. You will probably want a note of the meeting anyway as well, because that's much easier to use when the decision maker is drafting the decision letter and for any later appeal. This could be a transcript of the meeting if it's been recorded, or just a normal note. So that's definitely something to consider in advance. Although if you do want to record, you'll need the individual to agree. And if they don't, then you'll have to decide whether to bring in another person as a note taker. I would always say it is a good idea to have a note taker there unless you're recording, so that the person who is interviewing doesn't also have to take a note, because that could be too much to do. Now, you'll need to give some thought to how much the employee who is being investigated will see of the notes of the interviews or transcripts following a recording. If you're holding a disciplinary, they'll need to see all the relevant documents. This would probably be the investigator's conclusions rather than the interview notes and transcripts. But in some situations, it may well be reasonable for them to see those as well. And you may need to redact, in other words, sort of delete parts of them to protect confidentiality relating to other employees. Also, it's worth being aware that an employee can make a data subject access request, DSAR, at any time. This is something that the employee who is being investigated might do in order to find out more information about what witnesses have said, and perhaps they might be trying to delay or throw off the process. How do you deal with this in practice? It shouldn't slow down the process ideally, as you don't want to drag it out, as that's not good for anyone. You should deal with the DSAR separately, having someone else in HR or in the business deal with it ideally, and they can get on with searching for other information not directly related to the investigation while you continue. In terms of the documents arising from the investigation, you would need to go through a process to decide what the employee is entitled to see. But they may need to see the interview notes, and this is where redaction, so the deletion exercise, may be specifically needed to protect the confidentiality and to protect the data, the personal data of other employees. Now, moving to the right of our screen, communication is a really important part of this process, and not just communication with the employee who complained, but also the employee who's been accused. In the current circumstances, the mental health of employees is obviously a real concern, because many feel isolated working away from the office, particularly if they live alone. It can be very stressful at the best of times for an employee to have a grievance investigated or to be the subject of an investigation. So it's really important to ensure that they both feel supported and that they get regular contact from the business. And it's helpful if they know what to expect, when, and who from. You'll need to give some thought to the method of communication and whether it's sufficiently secure. Does it need to be separate from the ordinary email system, for example? Typically, I think ordinary email is fine, but sometimes individuals don't want to use their work email account and prefer to be contacted on their personal email. Now, once you've done all this and you've completed your investigation, you reach the final stage, the outcome, which Anna is going to pick up with and raise a few practical points.
Thanks, Sian. Yes, so the final stage in this process is the outcome of the investigation. And I think this is an aspect where most of the points that we're going to talk about are probably the same, whether you're in the remote world or back in the office. So if the investigation has revealed that there's a potential misconduct matter, then you may be proceeding to a disciplinary process next. If you're in a regulated sector, you may be having to notify the regulator. So if you're in financial services, the FCA, for example, or for lawyers, the SRA. And you may be having to make that notification well before any disciplinary process concludes, depending on the applicable regulatory rules. As Sian has just mentioned, and we've talked about in relation to all the earlier parts of the process, communication with the employee who complained and with the person or the people accused is absolutely key. Always important, particularly so where employees are working remotely and maybe feeling more anxious because they're not having that same day-to-day contact. Clearly, if there's going to be a disciplinary process, then the individuals involved in that will be told about that, and they'll be given all the information in the usual way before the disciplinary hearing. But you may need to think quite carefully about what you say to the individual who raised the complaint, partly depending on how they raised it. Either way, it's important that you tell them the investigation is being concluded. If the complaint from the individual came in through your grievance procedure, then of course you have to write to them with the grievance decision and also allow them to appeal. In contrast, if the complaint came through your whistleblowing or your speak up channel, then you may be giving them a bit less information and just the broad outcome. So the starting point here would be that you would let them know that the investigation is concluded and that you will be taking subsequent actions to deal with the issues that they raised. But it's really important to feedback as much as you can to whistleblowers, because one complaint which quite commonly arises in surveys about whistleblowing is that whistleblowers sometimes don't hear anything in response to their complaint. And this can lead them to believe that nothing is being done. And that, of course, discourages them and potentially their colleagues as well from raising issues in future, and potentially undermines the effectiveness of your whistleblowing or speak up procedures. So feedback is really important. Of course, there's a limit to how much information you can divulge, and there's certainly a limit to the information you can give about a disciplinary procedure, because you will want to make sure you're not breaching the confidentiality of the individual who's going to be going through that disciplinary procedure. But you can say the issues raised are being dealt with without going into that sort of detail. Also, it's worth thinking about any other communications that you might want to make at this conclusion of the investigation. So, for example, would you want to tell any witnesses that the investigation is concluded and thank them for their time and their help? That can help to reinforce the message that you're keen for employees to raise issues and that you will deal with issues and that you appreciate employees being prepared to cooperate. So it can be a positive thing to do. At the beginning, we mentioned the possibility of the employee raising the issue anonymously or confidentially, which can limit the action you can take against the person who's been accused. So, for example, if an employee complained that they or someone else has been harassed, but they don't want the perpetrator to know, you may not be able to take disciplinary action, but you might consider rerunning your diversity and harassment training for all managers to try to address the issue that way without singling anybody out. And of course, that can be done remotely just as effectively as it can be in person. And throughout this year, we've run a lot of these sorts of training sessions remotely. And aside from discrimination and harassment, there may be other situations where training might be relevant. So for example, if the complaint has revealed that there's a compliance problem in a particular area, say data protection or a regulatory process, for example, then you may need to roll out further or repeat training on that. Or the complaint may have identified an issue which you conclude hasn't been properly addressed in your policies or procedures, so you may want to revisit those and make any necessary changes. And of course, one possible, not uncommon outcome of any complaint is that one or more of your employees ends up leaving. Now, this might be the person who raised the complaint, it might be the person who was complained about, it might be both. And you may end up entering into a settlement agreement with the departing employee, depending on the circumstances. I think settlement agreements are really something of a separate topic in themselves, but there's one point that we thought was important to highlight here about settlement agreements in a context where a complaint has been made, and that's about confidentiality. Now, clearly, if an employee is leaving after some sort of complaint, then confidentiality is particularly important. But you do need to make sure that in all settlement agreements, and especially in these sorts of scenarios, that it is clear in your agreement that the confidentiality provisions won't prevent whistleblowing disclosures or disclosures to the police or a regulator. In due course, we are going to see legislation on specific requirements around confidentiality obligations in settlement agreements in sexual harassment cases. And employees will actually have to take legal advice on those provisions in those circumstances, but we don't yet have a date for that legislation, but that area is going to change. But I think the area where remote working has the most practical impact, as we've seen, is on the conduct of the investigation itself, as Sian outlined. And Sian, I think you wanted to round up with the key takeaway points on this.
Yes, thanks, Anna. So final points. Although much of what you have to think about in an investigation will be the same, whether it's remote or whether everyone is back at work, there are some key considerations when it's carried out remotely. And to round up, we wanted to leave you with these key takeaway points to think about when it comes to remote investigations. One of the most important considerations is the way in which the normal procedures have to be adapted to be carried out remotely, and being very clear to everyone involved exactly what that will mean and how it will impact on timescales. It's essential to manage expectations, and if there is litigation later on, you will need to demonstrate that there was a proper process that was clearly articulated and adhered to. As part of adapting your procedures, you'll need to give thought in advance to the practical questions we talked about earlier in terms of how you collect evidence, how you share it and make sure it's kept confidential, how your interviews will work, will you video them, and any protocols you want to put in place around these. And the other key considerations around communication and supporting the employees involved. You should make sure that your communications about the process are clear and regular, and that everyone is kept up to date, both the employee who made the complaint and any individuals who are being investigated. And this is one of the ways in which you can help them feel supported, given the increased risk to employee mental well-being during the pandemic, when a lot of people are feeling anxious and isolated. Alongside the communications, you may also want to consider other sources of support, such as reminding them of any counselling programme or employee helpline you may have. So that's all that Anna and I wanted to cover today on remote investigations. We hope you found this webinar useful. If you do have any questions, or if there's anything we've said today that you'd like to explore in more detail, please do drop either of us a line, or you can get in touch with your usual employment team contact. Thanks for joining us today.